There are three possible claims in tort that Rosa could bring. Firstly, against her employers, the Tate Gallery, for personal injury and negligence, as she developed cancer in their employ using the Artium spray. To assess the strength of this claim, we must establish the breach of a legal duty to take care, which results in damage undesired by the defendant to the plaintiff, to use Winthrop's definition. The Tate has a duty of care towards Rosa as her employer, per Wilsons and Clyde, and so must provide a safe working environment. This duty is breached where the defendant's conduct falls below the standard of reasonable care, an objective standard from the point of view of the reasonable man or person. From this perspective, we can argue it would have been reasonable for the Tate to take measures to prevent any dangerous chemicals it uses harming its employees. The case of Latimer tells us we should ask how burdensome any precautions would be. Arguably, providing masks, better ventilation, or even using a safer chemical would have all been reasonable for such a huge organisation. We do not have all the facts on whether any of these were in place, and we also do not know medically how high the probability of harm was, but it's clear that the threatened harm was large. Any risk of cancer is something that should have been taken seriously by the gallery. Therefore, this should be sufficient to establish a breach. For the claim to succeed, we must also show that the Tate's actions helped cause her cancer. As Lord Dyson in the case of Hennigan lays out, there are three tests we can use to establish factual causation in disease cases. The first test is from Barnett and Chelsea, which requires us to ask, but for the Tate Gallery's negligence, would Rosa have got cancer? We can't answer this conclusively, as she also used the spray in her own personal projects and in the churches she volunteered at. Therefore, we must move to the second test from Bonington. This test, however, concerns cases where the disease is caused by cumulative effective sources. In Rosa's claim, it's been established there is no way to tell whether it was cumulative or if it could have developed from a single exposure. Therefore, we must go on to the third test from Fairchild. Where causation can't be proved in either of these ways, causation may be established if it is proved that the defendant materially increased the risk of the victim establishing the disease. We can clearly see that the Tate's use of the spray Artium materially increased her risk of contracting cancer. Had they used a non-toxic alternative or put in place any of the precautions already suggested in the 6 years she worked for them, then her chances would have been much lower. The case of Sienkiewicz also tells us that even low exposure can count as a material increase of risk. Although we do need more information on the precautions in place at the gallery, the timescale and frequency alone tells us there was indeed a material increase of risk. However, this factor of causation alone is not enough. To establish legal causation, we must ask whether the harm was too remote a consequence of the negligence, and whether there are any intervening acts which broke the chain of causation. There is a strong argument for the damage being reasonably foreseeable and thus not too remote. It's accepted in the medical community that Artium can cause cancer, and the Tate, as a large institution that specialises in art, should have been able to research the products it requires its staff to use. The only possible factor that could be argued by the gallery as a novus actus interveniens, or intervening act, is Rosa's use of the spray herself in her personal projects, or at the churches. However, this is more likely to arise as a defence of contributory negligence, as there is not medical evidence available for the gallery to argue that they definitely did not, in any material way, increase the risk of cancer. As a result, Rosa is likely to have a strong case against the Tate Gallery. She could also make claims against the London churches that she volunteered at. The actionable damage is again her cancer caused by the Artium. Here her claims, while similar, may not be as strong as at the Tate Gallery. A duty of care must be established, which is trickier, as she did not have an employment contract, as she was merely a volunteer. However, we can use the test set out by Lord Bridge in Caparo Industries. There must be foreseeability, proximity, fairness, justice, and reasonableness. If the churches could have foreseen the risk that would come with using the spray, then they have a duty of care that they are then breaching. Using the test of the reasonable person again, as it was known the spray could increase the risk of cancer, then simple research could have uncovered this, which the church should have done. Most reasonable people would be aware that any strong solvent is potentially dangerous, as all bottles carry toxic symbols. While more information is needed on the time she spent at each church, Rosa was likely in a relationship of proximity with all of them. As a volunteer, she was almost like an employee there. She would have had regular contact and a role of some trust and responsibility within the organisations. Stoven and Wise merely defined this requirement as a connection between the parties, clearly met in Rosa's case. Finally, the situation should be one in which the court considers it fair, just and reasonable that a duty of care is imposed. This would obviously be up to the discretion of the court, however we can predict some arguments that may arise. The church should be seen as an organisation like any other and be held liable as such. Their special status as a church or charity should not prevent them from being held liable, and their volunteers should be protected like any others. It was held in JEG in Portsmouth in 2012 that churches had a duty of care towards its priests like any other employer, no special status, and the court could agree that this should extend to its volunteers as well. McFarlane and Fisher made similar arguments for using analogous cases to show that churches do in fact owe a duty of care to the volunteer to ensure that the volunteer is not harmed by any foreseeable dangers. On these examples, it's likely that the court would find there is a duty of care. To establish breach, the facts are similar to Rose's arguments against the tape. The church should reasonably have done some research on the spray to ensure it was safe. Admittedly, we need more information on how Rosa used the spray at the churches and what, if any, precautions were in place to more accurately ascertain whether there has been a breach. If they failed to make clear to the volunteers that the spray could be harmful or provide any preventative measures, then they are also in breach. The issue of causation is also similar. We can't say that but for the church's use of the spray, she would not have suffered the disease. We can't say that there was a cumulative effect, but we can argue the churches all materially increased the risk of Rosa contracting cancer per Fairchild. Every use of the spray could have caused the disease to develop, and so they should all be jointly and severally liable. As addressed in the Tate claim as well, she could also satisfy the legal causation requirement, arguing the risk was accepted medically and the damage not too remote, and there were no intervening acts. It's unlikely, but not impossible, that Rosa also has a claim against Mr. Khan. Although Pippin and Shepherd tells us that as her doctor he has a duty of care towards her, the specifics of her claim mean it's likely to fail. She can't make a claim for personal injury against Mr. Khan, as his incorrect treatment did not cause her actual physical harm. His negligence instead reduced her chances of survival, and she had to wait longer to receive treatment. This means she would instead have to make a claim for loss of chance. The courts have been reluctant to accept arguments for loss of chance in medical negligence cases, as in the landmark case Hodson in East Berkshire, where the concept was rejected by the Supreme Court. In Gregg and Scott, it was held that the claimant must show the doctor's negligence made it more likely than not, i.e. over 50%, that he would not be cured. Therefore, it depends on which figure of Rosa's chance of survival is taken as correct by the court. If Rosa had been correctly diagnosed by Mr. Khan at the first appointment, her chance of survival were between 45 and 55%. If we take 45% as the correct figure, then the claim fails, as she was never more likely than not to survive in the first place. However, if the court takes the figure as closer to 55%, then she may succeed. As Mr. Khan had correctly diagnosed her in the first place, it's more likely than not she would have survived. In other countries, the idea of being deprived of valuable chance is enough. The judge in Rufo and Hosking in Australia applied this reasoning, but it would be a landmark precedent if the court were to apply this principle in Rosa's case. Therefore, this presents a huge problem with being able to ascertain how strong a claim Rosa would have, due to this evidentiary gap. If science can't ascertain her chances to a more specific degree, why should the court be asked to? Particularly where there is so much at stake, her claim will hinge on this figure being more or less than 50%. But there are also public policy reasons why the court would take into account that may make it more likely that they would not find Mr. Khan liable. Particularly in medical cases, the courts are reluctant to open the floodgates of claims, which could create a financial burden on the already struggling NHS. While academics like Baker have tried to argue the idea of a flood of personal injury claims being a myth, if this myth is still alive in the minds and eyes of the general public, the court may still be wary. These multiple reasons make it unlikely that a claim against Mr. Khan would be successful, and perhaps, as a result, Rosa should not pursue one. The strength of all of these claims also depends on what defences the defendants can raise. Both the gallery and the churches could raise the defence of contributory negligence. This, as established in Pitts and Hunt, places partial fault on the part of the claimant. They could raise this as long as there is a causative link between the claimant's actions and the harm in question, as in the Feathy and Hubble case. Then the defence will apply. They could possibly argue that as she used the spray on her own time, there is a link between that and her cancer. However, this is a partial defence, so the Law Reform Act tells us this would result in a reduction in damages rather than the claim failing altogether. They could also possibly raise the full defence of volenti non fit injuria, that she acted voluntarily. In Morris and Murray, this requires having full knowledge of the nature and extent of the risk, and freely and voluntarily agreeing to incur it. It's possible that as she used the spray in her own time, without any institution requiring her to, this implies she knew of and consented to the risk of using it. The timeline is not clear, however. If she started using it in her personal projects after she started working at the Tate or the churches, then this would counteract and imply that she trusted using the spray in her own time due to the fact she was introduced to it to her work and believed it to be safe as a result. Overall, Rosa's strongest chance of a claim is against the Tate Gallery, as she had a contractual relationship as an employee, so there was a strong duty of care. She also has a chance against the churches, even though she was a volunteer, as the facts are the same. There was a risk that could have been prevented. Finally, the case against Mr. Khan is weaker due to his status as a medical professional. The court would be less likely to find liability. However, it is still possible.